Great. Hey, welcome, Fallon. Really want to thank you for taking your time out to join us today to kind of give our listeners and viewers really part of this educational series to help them learn a little bit more about workers' comp. Because as you and I both know, that this is a very intricate system that they've kind of put together, and there's a lot of parties involved.
Yes, thank you
And
for having me today.
Absolutely. Could you start off and tell our listeners what sort of inspired you to become a lawyer?
Well, it's a little funny. I went to Hofstra for my undergraduate degree, and I was a finance major. And I happened to be graduating during the crisis of 2008, the financial crisis. There were no finance jobs. People who had years and years of experience were being let go, and they were taking entry level jobs. So I grew up very meager earnings. My house. My parents worked very hard, but we had the basic essentials. So I always worked throughout high school and college to put myself through college. And I just knew the writing on the wall. I was going to be graduating with some student loans and no job. So I figured a lot of people had spoken to me about going for my master's in finance, and that didn't really appeal to me. So then I thought, I want a job that will always be secure. So it was between a lawyer and a doctor because before I became a finance major, was an engineering major. So I did have enough science that I could take my MCAT and maybe have to take just a few summer classes and I could go to med school. Um, so I was debating between the two, and my mom ended up having cellulitis in her arm and she needed help changing a bandage. And I went to help her. And I didn't know that when you have cellulitis, it's a very deep wound. And I pulled off the bandage and packing came out and I saw the wound and I passed out.
Ooh.
And at that point, I told my parents, I'm going to go to law school. Doctor is not for me. So I actually didn't have enough money to take the LSAT course, that a prep course to study. So I bought the LSAT books from Barnes and Noble, and I was trying to learn that way. And one of my family members who had, some additional income, they actually paid for my LSAT review course. Generally, people will study for 6 months to a year for it. I studied for about 3 months, and I took the LSATs, and then I got into New York Law School, and that is how I became a lawyer.
That what a story you got there, man. Sort of a my parents thought the same thing of, hey, you're either going to be a lawyer or a doctor. And I knew right off the bat that when I saw other people's blood, I would get goosebumps and I would get this noxious feeling in my stomach.
Oh,
And I was like, oh my God, I'm not cut out for this, but I can do everything that is active and moving. And I started with pre-med, and like most kids going into it thinking that they want to go to med school, specialize.
right.
I found exercise science and I'm like, oh my God, I did not know this thing exists. And I jumped right into it and took me and just took off.
That's
So
great.
that's really cool. That's really cool. Um, so diving right into sort of the workers' comp world, does workers' comp, according to the medical treatment guideline, what's their definition of an injury on the job?
So, in order to have an injury on the job, we use an acronym called ANCR, Accident, Notice, and Causal Relationship. In the state of New York, if you are injured during the course of your employment, you are covered. And there are several ways to be injured. You can have a slip and fall where you hurt your arm or leg. Okay. You can also have something called a repetitive trauma claim, which is where if you constantly use your hands or you're constantly lifting, you can't pinpoint one specific point in time where you fell or twisted your arm or you lifted something heavy, but you have pain that's just evolved. So there are many different types of injuries that you can have in workers' comp, and they're not limited to physical injuries. They can also be psychological as well.
And that sort of brings on to the next question that you kind of went ahead on. What's sort of a psychological injury that's a lot common in certain industries that probably aren't spoke about on a regular basis? At least, obviously, I don't see it because I'm a physical therapist by trade.
So there are two types of psychological injuries that you can incur during a workers' compensation claim that I see. One is common when someone gets physically injured and then their way of life has changed. They're hurt. They're not working. They have a reduction in income. They are not social like they used to be because of their injury. And they then sometimes get feelings of depression, anxiety, mixed emotions. That would come in as something called a consequential injury. When you were injured initially physically, you didn't incur a psychological injury, but from the physical injury, that has now caused some psychological trauma. People can even develop PTSD, either from the accident itself, depending how it happened, or from just the injury itself. People can develop PTSD. So though that is one branch of psychological injury that can occur, and that usually occurs as a consequence of a physical injury. There are also pure psychological claims that can occur. Um, those claims are harder. They're under a section of the law called Section 2.3 of the Workers' Compensation Law. And it means that you have a purely psychological injury from a condition at work, which means you weren't physically injured, but let's say you are constantly being berated by an employer, or an employer crosses a line, whether it's verbal or sexual or physical. That can create a psychological injury. But that area of the law is a little bit more difficult. You have the claimant's attorneys and the claimant has to get over a hurdle of the section of the law. That means it has to be above and beyond that is in the normal course of business. So what that means is, let's take an example. Let's say you work for an office and your office manager is very strict and they write you up and they're constantly reviewing your work and they are constantly, you may feel degraded, but talking about your work, talking about how you're doing, that may not get established, even if the office manager is not nice or uses harsh language or writes you up. That could still not be seen as getting over the burden because that may be considered in the normal course of business. Whereas, let's say someone is molested or assaulted, those are clearer and easier to obtain. That is not something that should happen in the normal course of business.
Gotcha. Huh. Interesting. And if I had a prior injury on their job and then there's a claim on file and I re-injure that same body part, what should I do afterward?
So, just because you injure a body part in the past, whether that claim is open or closed, does not mean that you can't re injure the same body part. Actually, as Dr. Lynn will probably tell you, once you hurt a body part, you could be more susceptible to re injuring it because it's weak. So, if you have a claim for a body part and then you re injure that body part, you would follow the same process. You would notify your employer of the injury, file a claim with workers' comp, and seek treatment. The only difference would be is that you are required to disclose the prior injury to your employer, the insurance company, and the doctors that you're treating with.
Gotcha. And would the same process apply if it was with a different body part or additional one?
So if let's say you injure a new body part and you have a new accident, okay? So an accident is an event. You have a new event, a new accident. Then you would first thing you would do is notify your employer of the injury. Some employers are very sophisticated and regimented, and they will have you fill out an incident report, speak to HR, and get you in contact with your insurance company. Sometimes in smaller companies, it may not be that streamlined because they don't deal with a lot of injuries. But your first obligation is to notify your employer of the accident. Once you do that, you should seek medical treatment so that it's documented. If you have a claim already pending, and let's say originally you injured your right shoulder very badly, you're in pain, you let your job know, you go to the hospital, urgent care, a doctor's office, they treat you for your shoulder. A few days later, you're feeling pain in your wrist. That's okay. Go back to the doctor and document it. If you have an attorney, let them know, and the attorneys will make sure that it's added to your claim form and your claim.
Gotcha. And that now that we're sort of given the pandemic and that some of us are working from home and that at least we're also starting to see that their workstation isn't optimally set up the way it is, and a lot of times you're looking, you're babysitting and you're trying to work at the same time and you're at this kitchen table and you've got this other stuff, and over time that sort of could sort of injure your back or at least put your back at risk over the course of 6 to 12 months. And it's more of a sort of accumulation of things that add up to that point where all of a sudden now your back pain starts to come on. Now, and if you sit all day for work and then all of a sudden you're back, would that be considered part of a workers' comp claim if you were to file one? How does that work?
Yes, so that would. You would still be covered even though you're working from home. You're still working in the course of your employment. And if you are having back problems or spine problems from constant sitting over time, you would file it would be what's called a repetitive trauma claim, okay, or what we call ODNCR. It's an it's an it's an occupational disease, but it's just really a repetitive stress claim. So you would go about it the same way. You would contact your employer, let them know that you're having back problems due to what you believe is sitting, and then you would seek medical treatment. You would need a doctor to examine you, diagnose the condition, and give an opinion if they believe that sitting down repetitively for 6 to 12 hours at an inadequate workstation is what caused the injury to your spine.
And is there a time frame to report the injury?
So there is a statute of limitations on workers' compensation claims. It's 2 years, okay? And with occupational claims, such as repetitive trauma, it's when you knew or should have known that it was related to your job. And there's still that 2 year statute of limitations. It's also a very important aspect of workers' comp claims is notice. Remember what I said in the beginning? Accident notice causal relationship, ANCR, which is an acronym that we use. It's very important that you notify your employer. Generally, you have 30 days to notify your employer, but it's best if you do it within the first 10. Even if you don't notify them within that time frame, I would still encourage you to file a claim because there are exceptions to the rule. If there is no prejudice to the employer by notifying them late, you can still have an active and open claim.
Got it. And what would you tell someone who's got, who's worked for the company for 20 years, got injured for the first time, and has never done this before?
The first thing you should do is let your supervisor or human resource manager know about your injury and then seek medical treatment. Once you do that, most people do obtain a workers' compensation attorney to help guide them through the process. We, as workers' compensation attorneys, make sure that you get the medical treatment that you're entitled to. If you're out of work, the lost wages that you're entitled to, and you very may well be entitled to a lump sum for any permanent injury, depending on the body part that was injured. One very important thing to know is that you're not suing your employer. You cannot sue your employer in the state of New York. Every employer in the state of New York, even if they have one employee, is required to obtain and hold valid workers' compensation insurance.
Sure.
And the minute you get injured and you need medical treatment, you're and you tell the doctor, they say, "How were you hurt?" You say, "Well, I was at work." The doctor will stop you right then and there. You cannot use your private insurance. You are required to go through workers' comp.
Gotcha. Is there at any point, is there ever an exception if the patient decides to forego that and decide to use their private just because they don't want workers' comp to be involved? Is there
As an attorney, I would always tell someone if you're injured at work, seek treatment through a workers' compensation doctor. If for some reason your claim is not found to be compensable or covered under workers' comp, that doctor's office can then bill your private insurance once a determination is made by the judge.
gotcha? And what's the length of process in terms a of someone getting injured and filing a claim, and then the judge kind of determines whether or not this is a viable claim?
Well, it varies because there's several things that can happen. First you notify your employer of the injury. If you have a prudent and good employer, they will then notify their insurance company, and within a couple of days to 2 weeks, you should get notification or paperwork from that insurance company. If you choose not to have an attorney, you would kind of just have to wait and follow up with your employer to find out who the insurance company is and get a claim number so you can give it to the doctor that you're treating with. If you do have an attorney, we file certain paperwork directly with the state that also ensures that a state number is issued, and we find out who the insurance company is and get you a claim number. Once you file the claim, if the insurance company accepts your claim, perfect, you're covered. If for some reason the insurance company sends out a denial of the claim, then more times than not, you should seek representation because you would need a hearing by a judge to make the determination of whether or not the case is covered under workers' comp. When a case gets fought by the insurance company, it can take several months to get addressed and a determination to be made.
Absolutely, and that often delays their care and treatment that they
Yes,
would need to get the ball rolling.
correct. You should definitely seek that initial treatment, but then you may be very limited to what other further treatment that you have because a lot of the treatment in workers' comp needs authorization from the insurance company. And if they're denying the claim, they're not going to authorize that treatment. But you can go ahead and start the initial visit with the doctors and some pre authorized treatment. And if the case is found to be compensable under the law, the doctors will be paid retroactively. If for some reason the claim is denied, then the doctors would bill your private insurance.
I certainly find that people who have representation or have seek out an attorney have far less headaches because they don't know how to navigate the system, and they're trying to balance more than three. They have a lot more on their plate than they can chew at that time, and it's just the logistics and the galleys of getting these adjusters to respond.
Correct. A lot of times, even my office and myself, I can't get an adjuster to respond. I have to request a hearing from the court. And that, for even me and my firm who's experienced in doing this, can take several weeks to even months. Workers' comp is a voluminous industry on all sides. People get injured every day. That means there's a lot of claims for for doctors. There's a lot of claims for claimants attorneys, and there's a lot of claims for the insurance companies and the adjusters. Sometimes these adjusters are terrible, and sometimes they're just completely overwhelmed by the volume. So
Gotcha.
we
Sometimes
take that anxiety and stress away from it for you.
100%, absolutely 100%. And sometimes I tell some of our clients to bring in some cookies to the adjuster so you can drop them off, and you can see them in person and ask them these questions.
And that's if they're even most of them are now working from home. So the only way you
Exactly.
can get in contact with them is through email.
Exactly. Exactly. Um, Now, if someone is undocumented and they got injured, what would you tell them would they go through a similar process?
Yes, your legal status has no bearing on your right to file a workers' compensation claim. If you are undocumented and working with no social security number on or off the books, you are covered. This does not get reported to ICE or immigration workers' comp. You don't need to be scared. You are not, if you think you're doing anything wrong, guess what? Your employer is doing wrong as well. So there's no culpability there. And there's no questioning on it, nothing. The only thing that gets difficult if you're working off the books is to prove your wages. Because if you're getting paid in cash, there's no paper trail of what you are actually making. So it will all determine on what the your employer reports to the insurance company what they were paying you. And then if there's a discrepancy, if let's say your employer says, well, I was paying him only $300 a week. And you're like, no, I was making $800 a week. There's no documentation to prove it. It will come down to testimony and who the judge basically believes is more credible.
Good. Would the same apply if a volunteer or intern was injured on the job?
So volunteers and interns get a little tricky. There is an area of the law for volunteer firefighters and EMTs. They are covered under workers' comp. A lot of volunteer firefighter and EMTs, that is not their only job. They also have secondary employment. Generally, if you have two jobs and you're injured at one job, you can get compensated for the loss of wages from both jobs. It's called concurrent employment. So let's say you work at Costco. You're injured at Costco, but at night, you also work at BJ's. You would be entitled to compensation of your lost wages from both jobs. We would prove that by showing your pay stubs and your W-2 from your second job to prove your wages. And you'd be able to be compensated from both if you're out of work from both jobs due to the injury at one job. With volunteer firefighters and EMTs, we are not allowed to establish that concurrent employment. So they are entitled to medical treatment and lost wages, but it's set at a statutory rate. The maximum you can receive is $400 a week if you are a volunteer fighter, fire, or EMT, and we can't include wages from another job. If you are a paid intern, you are considered an employee, you'd be covered as well. If you are unpaid intern or a volunteer worker, I would still encourage you to file the claim for medical treatment, but then we can't prove lost wages on your claim because there were none.
Gotcha. So you spoke and alluded this a little bit about sort of the next step after notifying your employee is to seek out treatment. The first person that most people think of when it comes to the injury is seeing their primary doctor. Is that someone is that something they can do right away, or do they have to find a specific doctor that takes workers' comp?
So generally, you should ask your primary care doctor if they accept New York State workers' comp as insurance. Some do, and they will do the initial evaluation of you and then refer you over to a specialist or a facility that really handles workers' comp. If your primary care doctor does not accept workers' compensation insurance, your best bet is to ask for a recommendation for a doctor that does and start there. You can even start at an urgent care because they accept New York State workers' comp insurance. The reason why it's so important to see treatment with a doctor that takes New York State workers' comp insurance initially is because in order to get compensated if you're unable to work from your work-related injury, you must have medical evidence from a doctor documenting your injury and what's called a degree of disability, your ability to work. And that generally needs to come from a workers' compensation doctor.
Could a nurse practitioner or a doctor of chiropractor, or does it have to come from an MD specifically?
No, it can be a nurse practitioner, a PA that are all under the supervision of a doctor, as well as a chiropractor. A chiropractor is 100% okay to use as your first line of treatment for spinal injuries.
Um, if the workers' comp doctor prescribes PT for someone who just filed a claim, does the patient, and often patient sees the script as an authorization that they can start getting treatment, but they don't understand that there's a difference between the two. Could you explain that a little bit to our audience and
Yes,
viewers?
there is a big difference. A script from a doctor for physical therapy is a doctor's order telling the physical therapist what type of treatment they prescribe for you. It is not authorization under the Workers' Compensation Board. Certain treatment is pre authorized. When you initially get hurt, and if your claim is accepted for the body parts that you injured, you are entitled to a certain amount of physical therapy that's pre authorized. It's generally around 12 visits, 4 weeks of treatment, sometimes more depending on the body part. And that all goes in accordance with the medical treatment guidelines. After that, once you have that initial amount of treatment, your doctor will then need to submit a request to workers' comp for additional treatment. This request is now submitted through what's called a PAR system. It's a medical portal where your doctor will submit online the request for treatment. The insurance company will then have either 8 business days or 15 calendar days, depending on the treatment that's being requested, to respond. If that treatment is authorized, beautiful, you can go and have the treatment. If that treatment is denied, then your doctor's office has to submit for a review. It goes from level 1 to level 2 to the highest level of level 3 review. Once it hits level 3 review, if it's been denied at level 1 and level 2, the medical board will come in and review the request and determine whether or not it will be authorized. And the medical board office is a separate entity from the insurance company.
Gotcha. And then let's say after the first authorization that the patient, um, that after the first authorization, the doctor believes that more PT is needed and it's helping. What happens thereafter?
The doctor would submit another request and they have to document your functional gains that you've received so far from the physical therapy and what functional gains they believe you will have in essence from the additional round of physical therapy that you're having. And that also goes for chiropractic care and medical acupuncture.
So I often find that there's usually a gap in between treatments between the first authorization and the second authorization. Is that typical, or is there any way to kind of bridge that gap in terms of from the first batch to the second batch?
Unfortunately, it is typical and it's very hard to bridge that gap because, in order for a doctor to submit a subsequent request for authorization for treatment, they have to document those functional gains that you've received from the prior treatment. So, you need to be either completed or almost completed from that initial round of treatment. And then the doctor's office has to submit the request, which they have many patients, and that can take a day to several days for them to actually submit the request. And then on top of it, the insurance company has anywhere between 8 business days to 15 calendar days to respond. So a lot of times it is very frustrating, but there will be a gap in treatment.
And you briefly kind of talked about the set of visits that someone is pre-authorized um, to have after they file an injury. This is more of a provider question in terms of treatment. We usually like to kind of keep things black and white with workers' comp. And we like the first thing we do after we get a form or a claim number from 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 a prospective patient is to reach out to the adjuster and then ask if they're authorized. And you sort of said, is in terms of the relative to each body part, is it usually 12 visits pre-authorized for each body part if that's the first treatment for physical therapy that they're seeing?
Yes, it's generally about 12 visits. It does depend on the body part. I do see sometimes there's 16, but it is per body part. Um, what that means is you can split the treatments. You know, you can go, let's say you injure your shoulder and your knee, you can go for 12 visits to your shoulder and then 12 visits to your knee. Most clients like to treat concurrently for both body parts at a time. It is always good if the doctor's office reaches out to the adjuster to make sure that the claim is accepted. If the person doesn't have an attorney, if they have an attorney, the doctor's office can reach out to us and we can let them know if it's accepted by documentation that would be required to be filed by the insurance company. And then a lot of times the doctor's office will verify what body parts the insurance company is accepting as an injury site. You can list several body parts as an injury, such as your shoulder, elbow, or knee, and the insurance company may say, we're only accepting the shoulder. And then we have to get a hearing to get all the body parts included.
Gotcha. What other treatments are folks who are injured entitled to besides physical therapy?
Acupuncture, which is medical acupuncture under the Workers' Compensation Board, which means a medical doctor has to actually provide the treatment, as well as chiropractic care. There's also pain management that's available to clients, such as epidural injections, steroid injections, synthetic knee injection. Pain management is also an available avenue to clients for treatment. And a lot of times you'll be recommended first for physical therapy before, or chiropractic treatment or acupuncture before the doctor will then start to send you for pain management.
And are there any, will workers' comp cover treatments that aren't recommended by the doctor?
No. So any treatment that you want to have has to be recommended and requested by the doctor. And it also has to be a recognized modality of treatment under the workers' compensation law. So, like I said, medical acupuncture is covered, but regular acupuncture isn't. So what that means is there's two types of acupuncture. There's acupuncture that's administered by an actual doctor, and then there's acupuncture that's administered by a licensed acupuncturist. A lot of times the insurance companies will only pay for the medical acupuncture and not acupuncture that is administered by just a licensed acupuncturist. They have to basically be coded under the workers' compensation law in order to be covered. So if you go to, let's say, Dr. Lynn's facility and you're getting physical therapy and acupuncture, beautiful, you're going to be covered. If you go to the strip mall that has an acupuncturist, you may not be covered.
Noted. I did not know that they had a delineation between a medical acupuncture and a licensed acupuncture. And it's rare to see that a medical doctor would have.
Yeah. Most of the times, as long as the acupuncturist is licensed and coded by the Workers' Compensation Board, which means they're able to treat clients under the Workers' Compensation law, you will have no problem. So that's why it's very important that you look for a facility that's reputable, like Dr. Lynn's, or facilities that are very knowledgeable and take workers' compensation as a form of insurance quite often. So that way you don't incur these problems. Most of the treatment problems that I see that clients have is because they're going to a doctor's office that takes workers' comp, or a physical therapy or facility that takes workers' comp, but they don't take a lot of it. And then they're not familiar with the rules, the regulations, and the processes, and that causes a delay in treatment and detriment to the client.
And is the patient responsible for medical bills that the workers' comp does not pay? How's that?
So the way that it works is if your claim is accepted as established under workers' comp and you seek out treatment, that you are not responsible for any medical bills or balance billing that occurs from that treatment. So let's say, for example, you go to the doctor. The doctor charges $250 for your visit. Under the New York State Workers' Compensation law and New York State fee schedule, the insurance company only pays $150 of it. You are not responsible for that $100 balance, and you will not receive a bill from the doctor's office. If you do, contact the doctor's office immediately. Let them know that this is workers' compensation. You cannot be balance billed, and it's actually insurance fraud.
And could you talk about the treatments what treatments are outside of the medical treatment guidelines established by the Workers' Comp Board in 2010?
So a lot of treatments that we see that are not covered are certain types of injections or topical creams. Plasma-rich injections, which are called PRP injections, are seen a lot in private medicine and regular medicine, and private insurance companies do cover it, but workers' comp has not caught up with the science yet, and it's not covered. Topical creams such as Voltaren gel, lidocaine patches, those also aren't technically covered or seen as a modality of treatment under workers' comp. It doesn't mean that you can't get them. I do see times that a workers' comp insurance company or an adjuster will pay for them, but you are lucky if you are able to get it. It wasn't many years ago. That wasn't the case. There were there's actually tons of companies, compound cream companies, that were producing the creams and billing workers comp, and clients were able to get it. So there are some people that have a claim that's going on several years, and they say, hey, I used to get the cream, I used to get the patches, and now I'm not. And that is why.
And how's that guideline evolved since 2010?
Since 2010, there's been a lot of changes in the workers' compensation law in terms of medical treatment. A 2013 guideline was set out where it changed the process and the amount of treatment that a client can have. There are definitely more restrictions, and it's getting harder and harder to get treatment authorized after that initial level of treatment. There is just about 9 months ago, the Workers' Compensation Board even changed the way in which the doctors request treatment and how lawyers deal with it. Up until June of last year, if a doctor needed to request, let's say, more physical therapy for the knee, they would submit an MG2 form to the court and to the insurance company for the treatment. If the insurance company approved it, beautiful. If they denied it, the lawyer, if the client had a lawyer, could then go ahead and request review of it in front of a law judge. That's no longer the case. If a client needs additional treatment, the doctor's office has to submit the request through the PAR system. And if it gets denied, the doctor has to take it up the chain to the level 3 review. They have essentially cut out the lawyers in this process. All we can do is advise the clients of the status of these requests and work with the doctor's office to let them know, hey, listen, we got a denial. Can you request review of it?
So they're essentially kind of taking your work and kind of giving it to them
Yes,
without the background that they need,
correct.
that you went to school for.
Exactly. Even prescriptions have changed. Narcotic and pain medication is severely limited under workers' comp. It's
Mm.
tightly regulated as it is with the state because there's an ongoing opioid epidemic. And even medications, whether narcotic or not, must go through a prescription portal. And again, if it gets denied, the doctors have to take it up the chain of command, essentially. The lawyers cannot.
Boy, that's got to be a little bit frustrating to kind of have
It
that
is for
sort
clients
of.
and their office. And it causes some confusion because some doctors' offices, like I said, don't deal with workers' comp that much. They deal with it and they're not aware of the changes, even though they should be. And it is also very confusing. The Workers' Compensation Board never makes the change easy. They never give clear documentation of it or tutorials about it. And sometimes doctors' offices are referring clients back to us to tell us to let us know that the treatment was denied. That's great. We know it, but there's nothing we can do. The doctor's office needs to submit the request for review, unfortunately.
Right. And they probably don't want that additional level of appeal that they have, the 3 level of appeals that
Yeah,
that
it's
you
a
guys originally
burden.
take care of that.
Yeah, it's a burden on the doctor's office and their staff because let's be honest, the doctor that you see, the orthopedist or the chiropractor or the physical therapist that you see, it's paperwork. They're not doing it. They have office staff, just like my staff, to do that type of stuff. And that's necessary. If the doctor was doing it himself, he would not be able to see you as a patient. And it creates a burden. And it's a system that people are still getting used to. I am seeing now that it's been more time has passed. Doctors' offices and their staff are catching on to the process. And I do see that if the requests are filled out properly, since it does go to levels of review that are outside of the insurance company review, we're seeing sometimes more treatment being authorized now.
Neat. And I know they've moved a lot of things on to more of an online platform where they would submit it as opposed to faxing and snail mailing. Has that helped in terms of, obviously there's got glitches with starting the system? Has that helped things become a little bit more efficient in terms of the
Yeah.
process?
I do see now, instead of faxing it, normally if a doctor requested medical treatment, they would have had to fax it to the workers' compensation board and the insurance company. And it takes several days for it to become viewable in the client's file. Now, when they submit it through the portal, it's instantly viewable. I actually, as an attorney, signed up for notification. So if any one of my clients, there's a request for treatment, I get a notification of it that it was filed. I also get notification of the denials and the approvals. And a lot of times, if I will try my best to look at all of them, especially if I see approvals. I will jump into the file and email the client the approval myself. They will eventually receive a copy of the approval in the mail, but there will be a delay then. So if I can, I do try to email it to our clients.
Is there any way for us to get a hold of that notification as well if we were treating clients?
Yes, if you sign up through the workers' compensation board, there is an area for lawyers and the area for medical providers, and you can register so you get the email notifications.
Oh, I did not know that. That is neat. That would kind of
I watched
expedite
a
some of the stuff.
75-minute video to find that information out.
That is helpful. That's why, just the last time we jumped on the phone, you really kind of help and simplify things in less than 5 minutes. And I'm like, if I just needed that conversation, it's crisp, clear, simple English. That even though I've been working with workers' comp for quite some time, I have an understanding of the process, but they really beat around the bush in
Yes,
terms of
it's
what
very
they're asking
difficult.
of you.
It's very convoluted, and that's why it is good for people to be represented by attorneys, because we break things down. And it's also sometimes nice to hear from someone that you're not the only one, you're not being picked on by the insurance company. This is the unfortunate process. The
Yeah.
system was created to protect workers, but it's become a system that has changed into forcing people back to work as quick as possible with the least amount of expense to the insurance company.
100%. And the first thing that these workers feel is resentment of, oh my God, I've worked for this company for 30 years.
And a lot of times it's not even the company. Generally, what happens is if you're an employer in the state of New York, you're required to have insurance. You go out and purchase the insurance just like you purchase insurance for your car or your home or your apartment, and you take a policy with an insurance company. Most policies, that's where the employer involvement kind of ends. The employer will get no will if an employee gets injured and they report it to the insurance company will ask them for certain information to confirm the accident, what was reported to them, and payroll information and apps and time information, meaning if they're out of work or not. But after that, the way a claim is adjudicated and handled is up to the insurance company and the adjuster. Your employer has no direct say if your treatment gets authorized.
If I bought things that I need to help me recover from the injury, could I get reimbursed for it?
Yes. You do not need authorization for any medical supplies or braces or assisted devices under $1,000. So if you injure your wrist and you go into CVS and get a wrist splint on the advice of your doctor, there's a form called the C-257. It can be found on the New York State Board's website, or if you have an attorney will provide you a copy of one, and you will write in, what you bought, the amount, and attach a copy of the receipt, and you would be entitled to reimbursement. You're also entitled to reimbursement for mileage to and from the doctor's office if you drive, as well as reimbursement for two-way fare on public transportation to and from the doctor's office. That includes doctor's appointments to go see the insurance company's doctor, as well as your physical therapy, chiropractic, and acupuncture care. All those will be reimbursed as long as for the physical therapy, chiropractor, and acupuncture care, those were authorized sessions by the workers' compensation insurance company.
If you don't have a car with that, with would you be fully compensated as well?
So you'll be compensated for public transportation, the round trip rate. Um, for taxis and Ubers are a different story. It's generally mileage. If you have to take a taxi or an Uber, your doctor would have to write a medical note saying that you are unable to take public transportation. And then generally an attorney would have to fight to get you compensated for and reimbursed for taking taxis, cabs, or Ubers.
Gotcha. I did not know that. I don't think most patients are aware of that, that
No.
they could get compensated to and from medical treatments when
Yep.
they.
And if you, the
That's good to
mileage
know.
is set by the IRS code for that year. If you actually Google mileage and transportation reimbursement, IRS 2023, it will tell you the rate. I think it's up to over 60 cents a mile now.
Gotcha.
Inflation.
That's good to know. That's good to know. That is good to know. Oh man. Um, Legally speaking, how long does an employer have to hold the position of your job for someone who is injured?
So in the state of New York, you are considered an employee at will. Unless you have an employment contract or you have a union contract where you're part of an employee, an employer can terminate you at any time. What that means is if you are injured and you're unable to return to work, your employer cannot fire you for having the accident being injured, but they can terminate your position saying they need to replace you. Certain jobs, depending on the size of the company, even if there's no employee contract or employment contract, you will be covered under FMLA for 12 weeks. You don't see that at small companies. Those are generally larger companies.
If I'm injured, so if I'm injured at work, how would it affect my pay and my personal benefits I have with the company?
So each company is different. Again, if you have a union contract or you're part of a union or an employment contract, that will preside over everything, which means if your union contract says you can be out of work for a year due to a work related injury, your job must hold your exact position for 1 year. If that employment contract says that during that time that you're out of work due to your injury and you're not on payroll, that the union will cover your health insurance or the job will cover your health insurance, that presides as well. There, if you don't have a union contract, an employment contract, it varies with the employer and what their policies are. Some employers, if you are no longer on payroll, the money's not coming out of your check for your private health insurance. They are required to let you know and offer you COBRA. If you can't afford COBRA, you can seek health insurance on the New York Health Exchange, what a lot of people refer to as Obamacare at any point. You don't have to wait for enrollment because you've had a life-changing event. You lost coverage due to an injury. Some employers are really great and they will continue to cover the person's health insurance while they're out. Some are great in the sense that they will say, listen, normally $180 comes out of your paycheck. Write a check for $180 and we'll continue your coverage. But it varies job to job.
And does compliance with treatment prescribed by the doctor have an effect on a weekly or biweekly pay that they would get?
Yeah. So in order to be receiving workers' comp benefits from the insurance company, you're required to have up-to-date medical diagnosing your injuries and commenting on your ability to work or what we call degree of disability. If you're non-compliant with your treatment and your doctor visits, those benefits can be reduced or suspended.
Oh, that is, um, if if a death occurs in a job, are there death benefits for the surviving spouses and or dependents of the children?
Yes, there is. If unfortunately someone dies on a work-related injury, the spouse as well as children are covered. If there is a spouse and children, the weekly benefit that the that the injured worker, the deceased, would have received if he was alive would be split between the spouse and the children. If the children are under the age of 18, the spouse basically becomes the custodian for that money, even though it's split up between the spouse and the children. Um, if you are over the age of 18 but enrolled in full-time school, you would also be entitled to benefits from a deceased father or mother or caregiver. Um, if there is no spouse or dependent children alive, then brothers and sisters or mothers and fathers' parents can also file for a death benefit, but it's more limited. Also, what a lot of
Mhm.
people don't know, funeral expenses are covered as well, up to 12,500, I believe it's went up to.
Okay. And at what point is an injured worker considered partially disabled?
So there's two ways an injured worker can be determined to be partially disabled. One is if their doctor has feels that they have improved since the beginning of treatment and they are no longer 100% disabled, but maybe 75% disabled. Well, now you are partially disabled. Another way for you to become partially disabled is, let's say your doctor is finding you 100% disabled, but then the insurance company has you examined by their doctor and they find you to be partially disabled, let's say 50%. The parties can't come to an agreement and we have to litigate. And the judge makes the determination that you are partially disabled. That is another way you can be found to be partially disabled under workers' comp.
In terms of, and how do they quantify that disability in terms of from an evaluation perspective? Are there certain functional things that they've got to kind of have the patient look, kind of test the patient to see whether or not they can do those things?
So, one of the biggest things that's hard to swallow in workers' comp is that when a doctor evaluates you on your temporary degree of disability or any degree of disability, they're not looking at your work, they're looking at all work. And what that means is they're not looking to see if you, as a construction worker, are 100% disabled from doing construction work, but if you, as a construction worker, have any sort of work capacity. So, what that means is, can you the injured worker answer a phone for 3 to 4 hours a day from home? If yes, you have a work capacity then under the workers' compensation law. Whether or not you're qualified to do that job or that job even exists does not matter under workers' comp. And that's where it can get very hard and frustrating for an injured worker to be told that they're only 50% disabled when they say, I can't go back to my job. My job requires me to be full duty, 100%. Unfortunately, that's the standard that the courts use. And to be found to be temporarily totally disabled, when you actually start to litigate, it's very hard. They look at things as loss of bowel or bladder function, quadriplegia, quadriplegia, quadriplegia. It's a very hard standard. What I tell people is you do not want to be 100% temporarily disabled or permanently totally disabled in the eyes of the workers' compensation law because you're in really rough shape.
100%. 100%. Um, so if they're partially disabled and they find a job that pays less than what they earned before, could they qualify for reduced earning benefits?
Yes. So let's say before you got hurt, you were working as a construction worker and you're making $1,000 a week, and then you've been seeking treatment, you're feeling a little bit better. You can't go back to work as a construction worker, or you were let go from that company. So you find work somewhere else. Let's say you decide, you know what, I have knowledge of construction materials. I can get a job at Home Depot. It's not physical in nature. I'm walking around, I'm not lifting, bending, and you start making $400 a week from Home Depot. You would let your attorney know because or the insurance company know, but really you would need an attorney for this because we generally need a hearing to establish reduced earnings. You would supply them with your pay stubs, and then basically you would be entitled to 2/3 of the difference from what you were making now to what you were before. So, for example, you're making $1,000 before you got hurt, you're making $400 now. The difference is $600. You would receive 2/3 of that, $400 a week from workers' comp tax free. So you'd be able to collect the $400 a week tax free from workers' comp, along with whatever you earned from after taxes from the Home Depot job. But
Got
it
it.
is very important. One of the things that you do is that you let your doctor know that you have returned back to work, and they document that you have returned back to work in a light duty capacity.
And is the doctor usually the person who determines whether you are ready to go back to work?
Generally, it's a decision between you and your doctor if you feel you're able to return back to work, either to your prior occupation or or to a new job. Sometimes injured workers do feel that the insurance company is forcing them to go back to work. No one can force you to go back to work, but I do understand that as you get examined by the insurance company doctors, your benefits do get reduced or they can be terminated pending litigation. And that can cause financial hardship that forces the person to go back to work prematurely or what they feel prematurely, even their doctor may. But those are
You
life choices that you as an individual have to make, and we can't make for you as attorneys.
And then so using your example for the $1,000, if that's what you made earlier, and you end up working for Home Depot, if you made above that, let's say you make 1,200, will workers come in and reduce and take the 200 away, or
So once you start working under the workers' compensation law, you're entitled to notify the insurance company that you're working and they stop benefits because you can't receive workers' comp benefits and be working at the same time. You can receive workers' comp benefits if you working making reduced money. But if you're making the same or more money than you were before the accident, you are not entitled to workers' compensation weekly benefits. You must stop cashing the checks, let your attorney know if you have one, and let the insurance company know if you don't have an attorney. Um, you would still be covered medically though. And you could still be entitled to a lump sum for any permanent injury, depending on the body part that you injured.
if my benefits were cut, what do I do next?
If your benefits are cut, you need to speak to your attorney first if you have one to see why they were cut. Were they cut because I went and saw the insurance company doctor and the insurance company reduced them and now we need a hearing to get them increased? Were they cut because my doctor found me to have less of a disability than before? Or were they erroneously cut by the insurance company? And there is no reasoning for it. If you don't have an attorney, then you need to contact the insurance company adjuster directly and find out the reason for the change in your benefits.
New York became a cap state in '07, and I found that out through your website. Um, could you tell our viewers and listeners what that means?
So, what that means is before 2007, if you were injured at work and you were found to be permanently disabled and you were unable to return to work, or you returned to work but in a reduced earning capacity, you would be entitled to biweekly payments from the insurance company for life. That is no longer the case. Workers' comp benefits are no longer for life. At the point in time in which you're found to have a permanent partial disability, that will determine how long you receive benefits for and at what rate from that point forward. There is a caveat. If you're found to be permanently totally disabled, which is very hard and rare, then you will receive those benefits for life, unless you return to work, of course.
And then what is the labor market attachment, and how do you prepare for someone when someone is told to go back or to start looking for work?
So, labor market attachment occurs when a person is found to be partially disabled, whether from a judge's decision or their doctor has found them to no longer be 100% disabled. At that point, you have an obligation to look for work within your physical restrictions. It doesn't mean you have to start working or actually find or get hired for a job, but you have to do a good faith effort. Most people look for work online through Indeed. You have to submit a copy of your resume and digitally look for work every day, as many days, or not every day, as many days as you can online, and document the search. There are certain forms called the C258 as well as the C258.1 that you are required to fill out. Another way to also ensure that you are looking for work properly and in accordance with the workers' compensation law is to join a Workforce One uh, program, which is designated through the state, and they have training programs and they help you look for work. If you are obligated, if you are directed to look for work because you're found to have a partial disability by either your doctor or the judge, that and you don't look for work, then your workers' comp benefits will stop.
If so, when there comes a time when someone receives a letter in the mail to see an independent medical examiner, is there a way? Are there suggestions you would? How would someone prepare for that examination?
The best thing that what I tell all my clients is when they get an IME notice to see the independent medical examination is my thoughts are they're not really independent. They are paid by the insurance company. There is no doctor patient relationship between you and that doctor. They have no ethical obligations to you. So always remember that in your head. Take that for a grain of salt with the examination. A lot of clients tell me the examinations are very quick and not thorough. Again, they are not your treating doctor. They have no responsibility to you. The best way that I tell a client to prepare for these examinations is to pretend that you are going to your doctor for the first time. Be honest, consistent with how you present yourself to the outside world and your doctor with this insurance company doctor. You then, once you're seen by the insurance company doctor, they will have 10 business days to place the report in the mail. You will receive a copy of the report. If you have an attorney, they will receive it as well. If you disagree with the IME report findings, it is good that you have an attorney because then we can fight that report for you.
And what if they ask me questions that may not be related to the injury that I'm seeing them for?
So if they ask you questions regarding your physical state, as well as any prior injury that you may have, even if it's not to that exact body part, you should answer them truthfully because sometimes they do have a bearing. So, for example, if you now have an injury for your right arm and they're going to evaluate your range of motion, it is important for them to know that you had an injury to your left arm in the past, even though it's not the same body part, because you may also have restriction in range of motion for the left arm as well. If they don't know that, they may think that your restriction of range of motion from your injured arm from this accident is not due to the accident, but just due to how your body's set up.
Okay.
So it is important to disclose that information. If you feel that they are getting too personal or the questions are completely out of line, you can tell them that you don't feel that it's pertinent to your accident and you wish not to disclose it.
I didn't realize that, and I found this on your website. This is really informative. Um, that you're allowed to videotape your exam if you tell your doctor's office, and you're allowed to bring a chaperone with you to witness the exam with her. I don't think a lot of patients are aware of that.
Yes. So actually, if you look at the notice, it says it actually will document if the insurance company doctor plans to videotape it, which they have a right to as well, but they must notify you on the notice. We'll also tell you that you have the right to videotape and bring someone with you. But if you choose to do so, you must contact the number on that notice and let them know ahead of time that you plan on recording the examination and bringing someone with you. During COVID, there was more restrictions on bringing someone with you, but that was in accordance with the New York State restrictions that was set by the governor and the mayors.
Uh, Getting injured at work is one thing. Coping with the emotional aspect of it is another. With that said, could you, and you've talked about a little bit of sort of the consequential effect of sort of the psychological effect of getting injured. Can one seek out a psychologist for treatment when they're dealing with an injury
Yes.
at the
So
same time?
if you feel your mental state has been affected from the injury, like I said, because you feel you're more withdrawn, you're having issues coping with the new limitations on your life, then you can definitely seek psychiatric treatment or psychological treatment. You should look for a doctor that takes New York State workers' comp. They will make an initial evaluation. And then if you have an attorney, the attorney would work to get that included in your claim. If you don't have the attorney, then you're going to have to do that. You have to contact the insurance company and hope they comply and help you along the way to get that included in the case. If not, you yourself would have to contact the workers' compensation board, send them a copy of the report from the psychological doctor, and ask for a hearing.
And with that, in terms of with that, is there a pre-authorized number of visits that usually comes with that, or is that the same process that you would?
This, the same process for physical treatment.
Gotcha, gotcha. Um, can't believe it's already been an hour and 10 minutes.
I
I
know.
want to. I want to be respectful of your time, and I think we might have to do a part two
I think so.
on this. But I want to say this has been really helpful and insightful, even for me as a provider, to kind of understand some of the nuances. And obviously, there's a whole lot more that gets sort of the nitty gritty that your line of work probably entails on a daily basis. And I find that a lot of patients who have in a representation and seek out an attorney are far more educated in terms of making the right decision.
Yes. Look, as an attorney, I will always recommend someone to get an attorney. The beauty of workers' compensation is that there are a lot of law firms out there um, that do handle them, some better than the other. But I work with some amazing people in my industry. I mean, even one of my competing firms is one of my best friends, and I do recommend their firm because they are great as well. So I would love for you to come to me, but there's amazing attorneys, and you don't need to suffer or be in the dark about this. You can get help and get the treatment that you need so you can heal and either get back to work or get on with your life.
Absolutely, absolutely. And we'll definitely have to do a round two to kind of wrap it up. But before we let you go, could you tell our listeners and viewers of what's the best way to reach out to you?
If you'd like to get in contact with us, you can go onto my firm's website. It is very long, the website. You would have to Google Severance, Burkos, Baltimore, Sony, and Lorette. I'm the Lorette. You could also just call the office at 718-625-2300. You can ask for me or any of our attorneys. My staff is amazing. The attorneys that I have working for me are amazing. We work in a team, and I couldn't do it without them.
There's nothing. The teamwork's dreamwork.
Exactly.
I think that the phone number is probably a better number to remember for our viewers and listeners. But what I would do is I'll put your website as well as your phone number in the description of this call, so that if they need to kind of reach out, they know exactly where to go.
Thank you so much. I appreciate it.
All right, we'll pick it up another time.
Sounds good. Thank you, Dr. Lynn. It was nice seeing you and have a great weekend.
Likewise, you too.